when the court appoints the executor, what gives the person the legal authority to go out and transact business on behalf of the estate?
A very important document called letters of administration.
And what do people hear? People often call us and say, "Tom, my mom passed away, and the bank says all I need is a letter to get access to her bank accounts." And we know a letter really means.
It really means probate.
Yeah. And the callers thinking, "Tom, can you just get me a letter?"
Yeah, they say, "Can you write me a letter?"
It's just a letter.
Yeah.
How much can it cost? It's just a letter. And we know that they really mean letters of administration. And letters of administration, of course, means it's a full probate administration.
Exactly. It's a full probate administration, and we have to tell those people, unfortunately, it's going to take a few months, more like 6 months to a year. Really just depends. And it will take a little bit more time and can be a little bit more complicated.
So people, maybe they've heard this term letters of administration. It is what gives the executor the legal authority to go out and transact business. So, for example, if mom passed away and daughter went down to the bank and said, "Well, here's mom's will. It says everything goes to me. Here's mom's death certificate. Hey, can you hand me over the money?" The bank's going to say no.
No.
But if you go down there with the letters of administration where you've been appointed by the court as the executor, the bank's going to follow whatever directions you give them.
Exactly.
So now we know letters of administration are important, but people are saying, "Well, what does it look like? What does a letters of administration look like?"
It's a one-page document, sometimes two, that gives the person the ability named to, as you would say, and I like your term with this, conduct business on behalf of the estate.
Right, and those letters of administration.
And it's signed by the judge.
It's signed by the judge. And that's what gives somebody the legal authority to transact business. And I was looking at some letters the other day, and I noticed something on there that I'd never noticed before. And by the way, the original letter stays in the court file. And then so the client doesn't get the original letters of administration. What do we give the client?
We give the client certified copies from the court. So we order them for the client, and then we give them certified copies.
And so what I noticed on the letters the other day is, I guess you guys have started typing on there, that it says that these letters are valid for 1 year.
Actually, the judges have been putting that on.
Okay.
So when we submit it to the judges, when they're signing it, they're the ones putting that on there.
And does it say 1 year from the date of the certified copy, or 1 year from the date that the letters are signed?
The date the letters were issued.
Okay. So I know that different probate judges, different counties, they all have a different way of doing probate, and that's part of your job description is to figure out, okay, how does this judge like it done? How does this county like it done?
Exactly.
But why would we not then be adding that standard language valid for 1 year from the date of issuance to all letters? Just because not all of them are requiring it?
Not all of them put that in there.
So question for you. If we're sending we file things now electronically, so you're filing electronically the proposed letters of administration. I would assume that's in PDF format. How is the judge typing those words
It's
over
not
there?
PDF. We actually submit it in a specific word format that the judge requires. That's what gives them the ability to put that in there. It's a very specific word format that we use for the judges.
Is that across the board, all judges, all counties throughout the state of Florida? So it does give them the ability, because, way back in the day, maybe even Perry Mason's day, it was actually the judge who would prepare the order. These days, it is 98% of the times, it is the lawyers who prepare the order.
Correct.
But by presenting it in this specific word format, it gives the judge the ability to tweak it a little bit.
Exactly. And so there's different ways of submitting orders to judges by county. It's not uniform in that way across the board, but the formatting for the orders, the letters, is very specific, so they can edit those things.
Okay, well, I find that fascinating. I've learned something new today.